And Mr. Naresh Dixit.
Yes?
My lord, there are some defects pointed out by the registration.
No, we ignore the defects.
So may
We
kindly,
don't take notice of all these defects. That shall be rectified later.
kindly post the matter on Monday if possible, my lord. Tomorrow, my lord, if possible.
Today.
Today after lunch, if possible, my lord, may kindly post the matter
Now.
after lunch.
What will I do then? क्या है पढ़िए साथ पढ़ते हैं हम.
Lordship, sir. Sometimes we give. After lunch, I'll be arguing this case. My lord, may kindly allow sometimes. In case if there is no any inconvenience caused to my learned friends.
No, I have no inconvenience. But
Tomorrow.
just one fact, if my lord,
Mr. Kejriwal, where is your file?
Lordships, I haven't got a copy of the LPA.
Will serve
You have
the
not even got the copy of the LPA.
No, not yet. And secondly, one more fact, my lord, if Lordship would permit. In this case, I think my friend will seek instructions from Naresh Dixit, sir. In this, the payments have already been made. The LPA which they have preferred against dismissal of civil review, we were in contempt. And there, my lord, they filed an affidavit, they made a payments in writ petition, whatever was the direction against which they had filed civil review application, which got dismissed, and against that they are here. That payment has already been made to us, an official.
That's all right.
Mila.
He is asking for an appeal against the order refusing to review the original order under which you got paid.
No.
So if the order is reviewed, if the appeal is allowed, you will have to return the money.
But that payment
Does it make this appeal infructuous?
that will make in my humble submission, because they have already passed an official order. The commissioner, their commissioner.
That's all right.
Mala.
So if we find, not that we are giving you any peace of mind, we
Mala.
don't know what has happened.
Yes, ma'am.
But taking clue from what you have said, now pursuant to an order passed by the single judge, you got your money back.
Mala.
Is that right?
Lord.
That was a consent order.
Mala.
But later the department thought that consent was unnecessarily given by the advocate.
Mala.
Right?
Lordships.
And then a review petition was rejected, quoting the same reason.
Mala.
That the lawyer, when he addresses the court, he has the authority, he has complete authority to decide.
Just what
the
my lords
future.
observed in the last case.
Yes.
Mala.
And therefore the review was rejected.
Mala. And then
Now should we find
Mala.
that the consent was ill-gotten, the consent was given without understanding the implications, and it is not for the benefit of the party for which concession was given,
Mala.
can we not review it?
Lord,
Order 47, there would be some dispute with respect to the application of Order 47. Not that we are going to do that,
Lord.
but you can't say that the matter has become infructuous, can you?
Only because they have complied with the order. They accepted the order, they've adhered to it. The order of the Honorable Single Judge. That is why I said, Mala.
Because the appeal was not taken up on time. Any such, if you make any payment pursuant to an order which you need to challenge, the payments or the compliance of the order is subject to the rights and contentions later and under protest. You know that.
Had they said so in affidavit, my lord, definitely I would not have
necessarily,
uttered.
it can be read, impliedly read in the action.
Then it can be examined.
Otherwise contempt.
Then it can be examined. Because contempt was going on. And
That's
there,
right. That's right. So for the fear of getting caught in the dragnet of contempt jurisdiction,
Mala.
many times orders are complied with. That's a good way.
Lord.
But subject to, I mean, these are subject to the registered protest or rights and contentions later. Now we are only talking of law, not
Yes,
fact
yes,
of your
my lord,
case.
definitely. Because in the last case, whatever my lords observed.
That's all right.
My lord.
But Mr. You are Sumit Pandey.
My lord.
Sumit Pandey.
Sumit Pandey.
Mr. Pandey, we prima facie we do not find any fault with the order passed in review.
Lord, sometimes maybe given I would satisfy this honorable court as to how that order is bad in the eyes of law as well as facts. Sometimes may kindly be.
How are you appearing in this matter? If the mines department has shown such no confidence in the council, I think you are the council with your senior.
My lord.
You did the best for your department, but the department says that you have wrongly used your discretion. Should you be appearing in this appeal?
For that sake, my lord, I very humbly submit.
Aren't you really upset by the way in which the department has treated you as a lawyer?
That may be possible, but I very humbly submit, my lord, the facts impugned here in order.
This is just to tell you that any person worth the salt, a lawyer worth his salt will not accept to challenge this. And as I see from the single judge's order, it was absolutely justified of the lawyer to have conceded that if an agreement cannot be given effect to, if all the minerals have been pilfered away, then there is no use carrying on that obligation, and therefore you permitted him to withdraw. Otherwise also the department would not have insisted. The only question was the return of the installment and the return of the amount security deposit that you conceded. The court was wanting it.
Later on, my lord, some dichotomous opinions accrued. Therefore, my lord, this LPA has topped up before this.
That's all right. The department can very well say that, but they should not have chosen you as a lawyer. That's our view.
The consent has been given.
That's
my lord.
our view.
Facts
The
may be
department should
examined.
not have chosen you. You should not have agreed to appear for such department in future. Anyway, that's your choice. You accept such contumacious treatment to you, and still you are ready to argue. What do I do? Please argue whenever you wish to.
So Monday may kindly post the matter.
As long a time as you wish to take. But I'm really happy that all these vague references about you not having done your part as a lawyer, still you are ready to defend your client. I am reminded of my lawyer days when I was appearing before a division bench, and the bench said that you must deposit 4 crores of rupees. And I said, all right. It was recorded that the lawyer conceded. The client said that no, I had never given instructions, but still, since the statement has been made by the counsel, you will deposit 2 crores. That's the trust between the lawyer and the client.
No, of course, we had given consent before the honorable single judge, but at the same time,
this is not on. I mean, in fact, I shouldn't be asking you because you are a junior counsel. Your senior had appeared in the matter.
So that's
Anyway, we give you time.
On Monday, may kindly post the matter.
As prayed for on behalf of the appellant, re-notify. There is no difficulty in appearing. I'm only telling you something which has struck me.
That is my.
Suppose some client says, some lawyer says that this matter may not be heard by this bench. I have lost faith. Would I insist for hearing the matter and pass orders? I will not. Even though there is a law, a specific law of recusal, but even then I will not.
For that sake, my lord, in case if there is any specific sort of.
I am saying this for different thing. Make your status so big that this kind of comment cannot come.
That won't be repeated in future, my lord.
Yeah. As prayed for on behalf of the appellant, re-notify on, give a date of your choice, Monday if it is inconvenient, any other Monday, 11th of July, whenever you want. It has lost its efficacy. You have complied with the order. Now we are not going to do anything unless you come out with some great law point. So whenever you want, let your senior appear whenever he wants.
On Tuesday, my lord,
In July, 11th
I'm giving you a longer time. Take your time.
11th of July we'll do.
11th of July. Chale next.
Selected Mr. Naresh Dixit.
Same.
Same issue.